Dear viewers, I'm your host Muhammad Asif Jaja and you are watching YouTube channel ETV 786. This channel is for everyone, education for business students and entertainment for general public. Welcome to your own channel. Please watch, like, share and comment the videos and subscribe the channel to view upcoming shows. On this channel, we have completed the basic concepts of accounting. 23 complete lessons may be watched on the channel. Now starting the second study course, Business Law. So let's start the course. Business Law. Definition of Business Law. Business law, also called commercial law, mercantile law, or the body of rules, encompasses all of the laws that dictate how to form and run a business. This includes all of the laws that govern how to start, buy, manage, and close or sell any type of business. Business laws establish the rules that all businesses should follow. A savvy business person will be generally familiar with business laws and know when to seek the advice of an attorney. Business law includes state and federal laws as well as administrative regulations. Scope of business law. Business law falls into two distinctive areas. Number one, the regulation of commercial entities by the laws of company, partnership, agency, and bankruptcy. Number two, the regulations of commercial transactions by the laws of contract and related fields. In civil law countries, company law consists of statute law. In common law countries, it consists partly of the ordinary rules of common law and equity and partly statute law. Two fundamental legal concepts underlie the whole of company law: the concepts of legal personality and the theory of limited liability. Nearly all statutory rules are intended to protect either creditors or investors. Forms of legal business. There are various forms of legal business entities ranging from the sole traders who alone bear the risk and responsibility of running a business, taking the profits, but as such not forming any association in law and thus not regulated by special rules of law, to the registered company with limited liability, and to multinational corporations. In a partnership, members associate forming collectively an association in which they are participate in management and sharing profits, bearing the liability for the firm's debts and being sued jointly and severally in relation to the firm's contracts or tortious acts. All partners are agents for each other and as such are in a fiduciary relationship with one another. Agent. An agent is a person who is employed to bring his principal into contractual relations with third parties. Various forms of agency regulated by law exist: universal, where an agent is appointed to handle all the affairs of his principal; general, where an agent has authority to represent his principal in all business of a certain kind; and special, where an agent is appointed for a particular purpose and given only limited powers. Appointment may be express or implied, and may be terminated by acts of the parties: the death, bankruptcy, or insanity of either the principal or agent, frustration, or intervening illegality. Insolvency. It is inevitable that in certain circumstances, business entities might be unable to perform their financial obligations. With the development of laws surrounding commercial enterprises, a body of rules developed relating to bankruptcy when a person or company is insolvent or unable to pay debts as and when they fall due. Either he or his creditor may petition the court to take over the administration of his estate and its distribution among creditors. Three principles emerge to secure fair and equal distribution of available property among the creditors: to free the debtor from his debts and to inquire into the reasons for his insolvency. Contract. Business law touches everyday lives through every contractual dealing undertaken. A contract, usually in the form of a commercial bargain involving some form of exchange of goods or services for a price, is a legally binding agreement made by two or more persons, enforceable by the courts. As such, they may be written or oral, and to be binding, the following must exist: an offer and unqualified acceptance thereof, intention to create legal relations, valuable consideration, and genuine consent, that is, an absence of fraud. The terms must be legal, certain, and possible of performance. Contractual relations. Contractual relations, as the cornerstone of all commercial transactions, have resulted in the development of specific bodies of law within the scope of business law regulating: number 1, sale of goods, implied terms and conditions, the effects of performance and breach of such contracts, and remedies available to the parties. Number 2, the carriage of goods, including both national and international rules governing insurance, bills of lading, charter parties, and arbitrations. Number 3, consumer credit agreements. And number 4, labor relations, determining contractual rights and obligations between employers and employees, and the regulations of trade unions. Business law and business students. Business law on national and international levels is constantly evolving, with new areas of law developing in relations to consumer protections, competitions, and computer and internet. If you are working towards your MBA or other graduate business degree, you will likely take business law twice, once as an undergraduate and again during your graduate program. You may wonder, especially if you are planning a career in business, that why students study business law. Always remember that businesses follow the law, and it's important to enter into contracts with the means of enforcing the agreement. Importance of business law for business. It is important for business owners, managers, and other professionals to have a basic understanding of business law to help them make better decisions. Just as there are laws that apply to people, there is a huge body of law that applies to business. Businesses need these laws for the same reason that people do, such as to define unacceptable behavior, to provide certainty and stability, to protect the public, and to provide a mechanism for business to resolve dispute. Throughout a business existence, it can do most things that a person can do, and we need laws to control these activities. A business can buy and sell property, sue and be sued, enter into contracts, hire and fire employees, and even commit crimes. Therefore, law protects businesses and people. Starting a business. Type of businesses. Much of business law addresses the different types of business organizations. There are laws regarding how to properly form and run each type. This includes laws about entities such as corporations, partnerships, and limited liability companies. For example, let's say you decide to start your own business. You need to decide what type of business. Will this be a partnership? Will it be a sole proprietorship? What papers do I need to file in order to start this business? These questions fall under the laws that govern business entities, and the type of entity you pick will also affect how you pay your federal income taxes. These, of course, are federal laws. Starting a business. Name of business. Next, what will be the name of the business? Let's say you decide on bond and cash as a name for your business. First, you need to know if anyone else already has that name. This is a trademark question. Patents, copyrights, and trademarks are a part of intellectual property law. Then you need to know if you require any special type of license for this business. You need to check the local and state laws to find out. How will you advertise your business? This question falls under consumer protection law, which can be federal or state law. Wow, that's a lot of business law, and you are not even open for business yet. Starting a business. buying a business. Now let's say you decide to buy a business instead. There are many businesses law that govern how to buy a business. If you want to own the actual store, this is a real estate law question. If you want to own equipment in the store, this is a property law question. And if you want to own employees too, this is an employment law question. If you want to hire your own employees and ordering supplies, this will be involved contract law. Contracts are legally binding agreements made by two or more persons enforceable by the courts. It is common for parties to dispute the terms of a business agreement or disagree on how the agreement should be performed. Managing a business. There are many laws that concern managing a business because there are many aspects involving in managing. As you can already see, running a business will involve a lot of employment law and contract law. For your new business, you will need to know how to hire, what your contracts should look like, what kind of benefits you have to provide, how to pay employee insurance and taxes, and even how to properly fire an employee. Many of these employment and benefit laws, sales law, debt collection law, quality control law, and many other laws are regulated and governed by local and federal government agencies. Employment laws. Especially in today's modern workplace, it is vital for any company with even one employee to stay abreast of current employment laws. Are you required to offer health insurance or workers' comp insurance? Has your business discriminated against an employee or stood by while one employee committed sexual harassment against another? There are many areas where your company could face major financial liability, not to mention the potential loss of reputation when treating employees unfairly. Immigration laws. There are more and more occasions where immigration law becomes an issue in modern businesses. Temporary employees, full-time employees, and special event workers may be from other countries. You need to know if you are following the law when dealing with foreign laborers. Consumer goods sales laws. The Uniform Commercial Code contains the law governing financial transactions in the United States. The code deals with everything from contracts to fraud to lease to secure transactions. Ambitious in its aim to consolidate the laws in one place, the code is actually quite complex. Lawyers spend a lot of time learning about how to apply the UCC to actual business practice and can give businesses advice on how to stay compliant with the laws while staying productive. Tax laws. Number 1. Income tax. For the profits of the company, which may be paid as personal income taxes for sole proprietorship or a single person LLCs or through a partnership business tax returns. Number 2. Sale tax. Sale tax on services and other products. Every state has different rules and there may be further complications when sales across state lines. If your business has a state income tax, you will probably be required to set up a system to collect, report, and pay the taxes you collect on a regular basis. Number 3. Property tax. On any real estate owned by your business, you may end up paying capital gains tax if you sell a business-owned property. Number 4. Self-employment taxes. So that business owner will still pay into Social Security and Medicare, normally employers take those taxes out of their employees' paychecks. Employment or payroll taxes, including FICA taxes for Social Security and Medicare and workers' compensation taxes. Dividend taxes on corporate shareholders. This is a kind of income tax based on the profits received from the business. And number 7. Excise taxes on certain products your business uses, like fuel. What are the functions of business law? Every business concern, either large scale or small scale, is bound to comply with their respective legal regulations. Here are some significant functions of business law that can help you in understanding it better. Number 1. Includes laws related to business ethics substantive law, procedural law, court system structure, and so on. Number 2, business law entails the taxation system for different types of businesses. Number 3, the level of competition and antitrust are also involved. Number 4, business law also includes regulations about employee rights and privileges, workplace safety, overtime rules, and minimum wage law. Number 5, it strives to alleviate the impact businesses have on the environment and nature. It aims to regulate pesticides, limit air and water pollution, chemical uses, and so on. Number 6, business law determines the formal process of establishment of a business organizations and regulations related to the selling of corporate entities. Number 7, it also includes rights assignment, drafting, and work delegations, breach of contract, transactions, contracts, and penalties for violation of the agreement. Number 8, business law defines laws related to business partnerships, entities, sole proprietorships, liability companies, and corporations. Number 9, it describes laws related to business and real property. Number 10, business law analyzes the overall impact of computer technology and other business domains. Number 11, includes laws related to bankruptcy and governance of the securities. Apart from these, business law is also essential to regulate corporate financing, regulatory compliance, and commerce litigation. Considerations when hiring a lawyer. Each industry faces its own unique business and commercial law issues. An attorney with experience in the type of businesses that your company conducts will be able to give you more practical advice and help you find a solution to your legal issue. That also takes business ethics and industry practices into consideration. Instead of trying to navigate the law on their own, business owners should consult a commercial law attorney early in the contract negotiation process to ensure that their legal rights are protected. Law and legal system. Law is a body of rules of actions or conduct prescribed by controlling authority and having binding legal force, that which must be obeyed and followed by citizens subject to sanctions or legal consequences. Legal system is a procedure or process for interpreting and enforcing the law. The system refers Constitution, adoption and amendment in Constitution, governing structure as judiciary, emerging powers, human rights, and law enforcement agencies, etc. There are 3 legal systems enforced in different countries of the world. Number 1, religious legal systems. Number 2, secular legal systems. And number 3, dual, hybrid, or mixed legal systems. Corporate social responsibility and business ethics. The concept of social responsibility does indeed have a long history in the world of business. Social responsibility has to form an essential part of the company's life because it has to be incorporated in its heart, transforming it internally. In the early 3rd millennium, the discourse on corporate social responsibility doubtlessly has remarkable global and local weight. Corporate social responsibility is a business model in which companies make a concerted effort to operate in ways that enhance rather than degrade society and the environment. CSR helps both society and the brand image of companies. Corporate responsibility programs are a great way to raise morale in the workplace. Courts and the legal process. A court is any person or institution, often as a government institution, with the authority to adjudicate legal disputes between parties and carry out the administration of justice in civil, criminal, and administrative matters in accordance with the rule of law. The system of courts that interprets and applies the law is collectively known as the judiciary. The practical authority given to the court is known as its jurisdiction. The legal proceeding is an activity that seeks to invoke the power of a tribunal in order to enforce a law. It includes proceedings brought by or at the instigation of a public authority and an appeal against the decision of the court or tribunal. It is an orderly process in which participants and their representatives are able to present evidence in support of their claims and to argue in favor of particular interpretation of the law, after which a jury makes a determination of the factual and legal issues. Administrative law. Administrative law is an arm of public law and is also known as regulatory law. Administrative law involves the administration and regulation of federal and state government agencies. Government agencies have purview over a wide variety of economic functions such as international trade, manufacturing, the environment, taxation, broadcasting, immigration, transport, telecommunication, the financial market, and the social issues such as instances of racial discrimination, social security compensations, etc. Civil law countries often have specialized administrative courts that review these decisions. Criminal law. Criminal law, the body of law that defines criminal offenses, regulates the apprehensions, charging, and trial of suspected persons, and fixes penalties and modes of treatment applicable to convicted offenders. The traditional approach to criminal law has been that a crime is an act that is morally wrong. The purpose of criminal sanctions was to make the offender give retribution for harm done and expiate his moral guilt. Punishment was to be meted out in proportion to the guilt of the accused. In modern time, more rationalistic and pragmatic views have predominated. Objective of criminal law should be to give fair warning of the nature of the conduct declared to constitute an offense and to promote the correction and rehabilitation of offenders. Tort law. Tort law is the area of the law that covers most civil suits. In general, any claims that arises in civil court, with the exception of contractual disputes, falls under tort law. The concept of tort law is the redress of wrong done to a person and provide relief from the wrongful acts of others, usually by awarding monetary damages as compensation. The original intent of tort is to provide full compensation for proved harms. Lawsuits involving contracts fall under contract law. Tort law requires those who are found to be at fault or harming others to compensate the victims. Typical harms include the loss of past or future income, paying of medical expenses, and payment for pain and suffering. There may also be additional punitive damages that are meant to punish the plaintiff in excess of full compensation. Contract law. Contract law is an area of United States law that involves agreements between people, businesses, and groups. When someone does not follow an agreement, it is called a breach of contract, and contract laws allows you to take the problem to court. Contract law attorneys and a judge will discuss the case and determine a fair solution. When a breach of contract occurs and one or both parties wish to have the contract enforced on its terms and attempts at informal resolution have failed, to aggrieved party can file a lawsuit in the appropriate civil court. In some cases, parties will attempt mediation before a lawsuit is filed. A party that is successful in mediation or court may be granted specific performance, an order commanding the breaching party to hold up their end of the agreement, or one of a number of different kinds of damages, including compensatory damages, punitive damages, nominal damages, liquidated damages, cancellation, and restitution. Agreement. An agreement is a manifestation of mutual assent by two or more persons to one another. It is a meeting of the minds in a common intention and is made through offer and acceptance. An agreement can be shown from words, conduct, and in some cases even silence. Agreements are often associated with contracts. However, agreement generally has a wider meaning than contract, bargain, or promise. A contract is a form of an agreement that requires additional elements such as consideration. Real assent. Genuine assent is a complete agreement between two competent parties. Following are the prerequisites of assent. Number 1. Contracts require a meeting of the minds between competent parties, and if there is no such meeting, the agreement is usually voidable. Number 2. Parties must enter the contract voluntarily. without duress or undue influence. Number 3. Misrepresentation or fraud when proven vitiates a contract. Number 4. A mistake may make a contract voidable. Number 5. Parties to a contract must have capacity that is not labor under infancy, intoxication, or insanity. Consideration. Consideration is a concept of a common law and is a necessity for simple contracts but not for special contracts, which are contracts by deed. The concept has been adopted by other common law jurisdictions. Consideration may be thought of as the concept of value offered and accepted by people or organizations entering into contracts. Anything of value promised by one party to the other when making a contract can be treated as consideration. For example, if A signs a contract to buy a car from B for $5,000, A's consideration is the $5,000 and B's consideration is the car. The doctrine of consideration is irrelevant in many jurisdictions, although contemporary commercial litigant relations have held the relationship between a promise and a deed is a reflection of the nature of contractual consideration. Legality. Legality is a concept of attachment to law as implied warranty that an act, agreement, or contract strictly adheres to the statutes of a particular jurisdiction. Contracts must be created for the exchange of legal goods and services to be enforced. An agreement is void if it violates the law or is formed for the purpose of violating the law. For a contract to be binding, it must not have a criminal or immoral purpose or go against public policy. For example, a contract to commit murder in exchange for money will not be enforced by the court. Third-party rights. The law related to rights of third parties give power to third parties in certain circumstances to enforce terms of a contract that confer a benefit upon them, either expressly or as a matter of contractual construction. For example, a right for the third party to receive warranty services may be made subject to the third party keeping the product properly maintained. In one instance, the court found that a third party's right had to be enforced through arbitration, as this was the method of dispute resolution which the contracting parties had chosen under the contract. No enforceable right will arise as a matter of construction unless the conferral of the benefit on the third party was a purpose of the bargain between the parties to the contract, and not just incidental to it. Discharge of obligations. Discharge of obligations shall be deemed to have occurred on the earliest date on which, number 1, all commitments shall have been terminated. Number 2, all obligations arising under the loan documents other than contingent obligations for unasserted claims shall have been repaid. Number 3, all letter of credit, LC facility deposits shall have been returned to the LC facility lenders. And number 4, no letters of credit shall be outstanding except to the extent consented to be issuer thereof pursuant to arrangements acceptable to such issuer in its sole discretion. Remedies. Any of the methods available at law for the enforcement, protections, or recovery of rights or for obtaining redress for their infringement are called remedies. Remedies are intended to make the non-breaching party whole. The two categories of remedies for breach of contract are legal and equitable. In the legal category are damages. In the equitable category are specific performance, injunctions, and restitution. The law does not force a party to perform. He or she always has the power, though not the right, to breach and may do so if it is economically more advantageous to breach and suffer the consequences than to perform. Remedies, though, are not usually intended to punish the breaching party. Sales and leases. A sale consists in the passing of title from the seller to the buyer for a price. Sales are distinguished from gifts, bailment, leases, and secured transactions. Lease is a transfer of the right to possession and use of goods for a term in return for consideration. The lessor is the one who transfers the right to possession to the leasee. There are two kinds of leases: Number one, consumer leases is used when a lessor leases goods to an individual primarily for personal, family, or household purposes. Number two, finance leases is used when a lessor acquires the goods or the right to them and leases them to the lessee. The person from whom the lessor acquires the goods is a supplier, and the lessor is simply financing the deal. Title and risk of loss. Title refers to ownership of a good. Whichever party legally owns the goods at a moment is the one with title. Risk of loss refers to which party bears the risk for damage or destruction of the goods. Notwithstanding the form of shipment, title, or other property interest, risk of loss shall not pass from the contractor to the authorized user until the products have been received, inspected, and accepted by the receiving entity. Acceptance shall occur within the reasonable time or in accordance with the such other defined acceptance period as may be specified in the bid specifications or purchase order. Any delivery of product that is substandard or does not comply with the bid specification or contract terms and conditions may be rejected or accepted on an adjusted price basis as determined by the Commissioner. Performance and remedies. The parties often set out in their contracts the details of performance. These include price terms, terms of delivery, where, when, and how the goods are to be delivered. If the parties fail to list these terms, the Uniform Commercial Code rules will determine the parties' obligation. In any event, the parties have an obligation to act in good faith. There are special remedies for those damaged or injured by defective products. The contract may be either a shipment contract, a destination contract, or a contract where the goods are not to be moved, being held by a bailee. In any case, unless otherwise agreed, the delivery must be at a reasonable time and the tender. The offer to make delivery must be kept open for a reasonable time. The buyer must furnish facilities reasonably suited to the receipt of the goods. Product liability. Defective or dangerous products are the cause of thousands of injuries every year around the globe. Product liability law is the set of legal rules concerning who is responsible for defective or dangerous products, but they are different from ordinary injury law. This set of rules sometimes makes it easier for an injured person to recover damages. Product liability refers to a manufacturer or seller being held liable for placing a defective product into the hands of a consumer. Responsibility for a product defect that causes injury lies with all sellers of the product who are in the distribution chain. In general terms, the law requires that a product meet the ordinary expectations of the consumer. When a product has an unexpected defect or danger, the product cannot be said to meet its ordinary expectations of the consumer. Bailment. Bailment is the rightful possession of goods by one who is not the owner. It is the element of lawful possession, however created, and the duty to account for the things as the property of another that creates the bailment, regardless of whether such possession is based upon contract in the ordinary sense or not. The law of bailment is important to virtually everyone in modern society. Anyone who has ever delivered a card to a parking lot attendant, checked a coat in a restaurant, deposited property in a safe deposit box, rented tools, or taken items, clothes, or appliances into a shop for repair. In commercial transactions, bailment law governs the responsibility of warehouses and the carriers, such as UPS and FedEx, that are critical links in the movement of goods from manufacturer to the consumer. Storage. Warehousing has been called the second oldest profession, stemming from the biblical story of Joseph, who stored grain during the 7 good years against the famine of the 7 bad years. Whatever its origins, warehousing is today a big business, taking in billions of dollars to stockpile foods and other goods. A warehouser is defined as a person engaged in the business of storing goods for hire, and a warehouse receipt is any receipt issued by a warehouser. The warehouse receipt is an important document because it can be used to transfer title to goods, even while they remain in storage. It is worth money. No form is prescribed for the warehouse receipt, but unless it lists in its terms the following 9 items, the warehouser is liable to anyone who is injured by the omission of any of them. Mandatory items of the warehouse receipt. Number 1, location of the warehouse. Number 2, date of receipt was issued. Number 3, consecutive number of the receipts. Number 4, statement whether the goods will be delivered to bearer, to a specified person, or to a specified person or his order. Number 5, the rate of storage and handling charges. Number 6, description of the goods or the packages containing them. Number 7, signature of the warehouser, which his or her authorized agent may make. Number 8, the warehouser's ownership of the goods, if he or she has a sole or part ownership in them. Number 9, the amount, if known, otherwise the fact, of advances made and liabilities incurred for which the warehouser claims a lien or security interest. Shipping of goods. Number 1, the shipment of goods throughout the globe is a very big business, and many specialized companies have been established to undertake it, including railways, air cargo operations, trucking companies, and ocean carriers. A bill of lading is a document that evidences the receipt of goods for shipment issued by a person engaged in business or transporting or forwarding goods. Number 2, the common carrier contains 3 elements. Number 1, the business is not restricted to particular customers but is open to all who apply for its services. Number 2, it must charge for his services. Number 3, the service in question must be carriage, household moving companies, taxi cabs, towing companies, and even oil and gas pipelines are the examples. Number 3, note that a common carrier may limit the types of goods or the places to which they will transport them. Leasing of goods. Leased good means goods that the contracting authority has chosen to lease from the supplier on a fixed term basis in exchange for regular monthly payments. The ownership of the leased goods shall remain with the supplier throughout the leasing agreement. When you lease goods from a merchant, you don't become the owner. Instead, you become the leasee, and the merchant remains the owner. The merchant can offer to leasee to sign. Number 1, contract of lease with an option to purchase. At the end of the lease, it's possible to buy the leased goods and become the owner for a price set ahead of time in the contract, which is called the buyback price. Commercial paper. Commercial paper is a commonly used type of unsecured short-term debt instrument issued by corporations, typically used for the financing of payroll, account payable, and inventories, and meeting other short-term liabilities. Maturities on most commercial paper ranges from a few weeks to months, with an average of around 30 days. Commercial paper is often issued at a discount without paying coupons and matures to its face value, reflective of current interest rates. Commercial paper is not usually backed by any form of collateral, making it a form of unsecured debt. Commercial paper is only issued by firms with high-quality debt rating. Only these kinds of firms will be able to easily find buyers without having to offer a substantial discount, higher cost, for the debt issue. Negotiation of commercial paper. Negotiation means that an instrument has been transferred, either voluntarily or involuntarily, to the holder by someone other than the issuer. The paper is negotiated upon. Number 1, transfer of possession. The transferee may become a holder upon transfer. A holder must be entitled to enforce the instrument. This excludes individuals who forge a signature on order paper. And number 2, endorsement, signatures by the holder. Endorsement is not generally required for bearer paper, as the holder is not necessarily named on the instrument. The holder of the instrument has the right to force the transferor to endorse the instrument. Holder in due course and defenses. In commercial law, a holder in due course is a person who takes a negotiable instrument in a value-for-value exchange without reason to doubt its legitimacy. A holder in due course acquires the right to make a claim for the instrument's value against its originator and intermediate holders. Even if one of these parties pass the instrument in bad faith or in a fraudulent transactions, a holder in due course may retain the right to enforce it. The holder in due course doctrine is important because it allows the holder of a negotiable instrument to take the paper free from most claims and defenses against it. Without the doctrine, such a holder would be a mere transferee. Liability and discharge. Agents often sign on behalf of principals, and when the authorized agent makes clear that he or she is so signing by naming the principal and signing her name as agent, the principal is liable, not the agent. But when the agent signs incorrectly or fraudulently, the rules says in general that the agent is personally liable to an holder in due course who takes the paper without notice that the agent is not intended to be liable. Unauthorized signatures, forgeries, are ineffective as to the principal. They are effective as the forger's signatures, unless the principal or the person paying on the instrument has been negligent in contributing to or in filing to notice, the forgery, in which case comparative negligence principles are applied. Legal aspects of banking. This is about the laws that govern the operations of the banking system with respect to its depositors and customers. Although histories of banking dwell on the relationship between banks and the national government, the banking law that governs the daily operations of checking accounts is state-based nowadays. To trace the traditional check collection process, it is necessary to understand the terminology used. The bank upon which a check is written is the payer bank. The depository bank is the one the payee deposits the checks into. Two terms are used to describe the various banks that may handle the check after it is written: collecting banks and intermediary banks. All banks that handle the check except the payer bank are collecting banks. Intermediary banks are all the collecting banks except the payer and depository banks. A bank can take on more than one role. Any other bank through which the check travels, except the two banks already mentioned, is an intermediary bank. Consumer credit transactions. Consumer credit transactions are consumer credit sales, consumer lease, a consumer loan, or a modification thereof, including a refinancing, consolidation, or deferral between a merchant and a customer in which real or personal property, services, or money is acquired on credit and the customer's obligation is payable in installments, or for which credit a finance charge is or may be imposed. Whether such transaction is pursuant to an open-end credit plan or is the transaction involving other than open-end credit. Lenders, whether banks or retailers, are not free to charge whatever they wish for credit. Usury laws establish a maximum rate of lawful interest. The penalties for violating usury laws vary from state to state. The heaviest penalties are loss of both principal and interest, or loss of a multiple of the interest the creditor charged. The courts often interpret these laws stringently, so that even if the impetus for a usurious loan comes from the borrower, the contract can be avoided. Secured transactions and suretyship. Debtor borrows money or obtains credit from creditors, signs a note and security agreement putting up collateral, and promises to pay the debt, or upon debtor's default, let creditor secured party take possession of the collateral and sell it. The grasping hand is creditor's reach for the collateral, but the hand will not close around the collateral and take it unless debtor defaults. The secured transaction always involves a debtor, a secured party, a security agreement, a security interest, and collateral. All actual and potential creditors of the debtor are always on notice that the bank with which the debtor's deposit account is maintained may assert a claim against the deposit account. Perfection can also be achieved by a pledge, that is, possession by the secured creditor, or by control of certain assets, that is, having such control over them as to be able to sell them if the debtor defaults. Mortgage. A mortgage is a means of securing a debt with real estate. A long time ago, the mortgage was considered an actual transfer of title to become void if the debt was paid off. The modern view, held in most states, is that the mortgage is but a lien, giving the holder, in the event of default, the right to sell the property and repay the debt from the proceeds. The person giving the mortgage is the mortgager or borrower. In the typical home purchase, that's the buyer. The buyer needs to borrow to finance the purchase. In exchange for the money with which to pay the seller, the buyer takes out the mortgage with, say, a bank. The lender is the mortgagee. The person or institution holding the mortgage with a right to foreclose on the property if the debt is not timely paid. like security interests in personal property and suretyship. The mortgage is the common type of consensual security arrangements. Non-consensual liens. A creditor may obtain certain liens without the debtor's consent, which are called non-consensual liens. There are four types of non-consensual liens. Number one, court-decreed liens or attachment liens, which prevent a person from disposing of assets pending a lawsuit, and judgment liens, which allows the prevailing party in a lawsuit to take property belonging to the debtor to satisfy the judgment. Number two, mechanics liens. Mechanic liens are authorized by statute, giving a person who has provided labor or material to a landowner the right to sell the property to get paid. Number three, possessory liens. Possessory liens on personal property allows one in possession of goods to keep them to satisfy a claim for work done or storage of them. And number four, tax liens are enforced by the government to satisfy outstanding tax liabilities and may be assessed against real or personal property. Bankruptcy. Bankruptcy is a legal proceeding involving a person or business that is unable to repay their outstanding debts. The bankruptcy process begins with a petition filed by the debtor, which is most common, or on behalf of a creditor, which is less common. All of the debtor's assets are measured and evaluated, and the assets may be used to repay a portion of the outstanding debt. Upon the successful completion of bankruptcy proceedings, the debtor is relieved of the debt obligations that were incurred prior to filing for bankruptcy. Businesses often file bankruptcy, the goal of which is to recognize, remain in business, and once again become profitable. Filing bankruptcy allows the company to create plans for profitability, cut costs, and find new ways to increase revenues. Their preferred stockholders, if any, may still receive payment, though common stockholders will not. Personal property and fixtures. Personal property is a class of property that can include any asset other than real estate. The distinguishing factor between personal property and real estate or real property is that personal property is movable, that is, it is not fixed permanently to one particular location. It is generally not taxed like fixed property. A fixture as a legal concept means any physical property that is permanently attached to real property, usually land. Property not affixed to real property is considered chattel property. Fixtures are treated as a part of real property, particularly in the case of a security interest. A classic example of a fixture is a building, which, in the absence of language to the contrary in the contract of sale, is considered part of the land itself and not a separate piece of property. Intellectual property. Intellectual property is a category of property that includes intangible creations of the human intellect. There are many types of intellectual property, and some countries recognize more than others. The most well-known types are copyrights, patents, trademarks, and trade secrets. The main purpose of intellectual property law is to encourage the creation of a wide variety of intellectual goods. To achieve this, the law gives people and business property rights to the information and intellectual goods they create, usually for a limited period of time. This gives economic incentive for their creation because it allows people to benefit from the information and intellectual goods they create and allows them to protect their ideas and prevent copying. Regulation of real estate and the environment. Real property is an important part of corporate as well as individual wealth. As a consequence, the role of the corporate real estate manager has become critically important within the corporation. The real estate manager must be aware not only of the value of the land for purchase and sale, but also of proper lease negotiation, tax policies and assessments, zoning and land development, and environmental laws. In property law, an estate is an interest in real property, ranging from absolute dominion and control to bare possession. A freehold estate is an interest in land that has an uncertain duration. A leasehold estate is one whose termination date is usually known. A one-year lease, for example. The transfer of real estate by sale. Property is sometimes owned by one person or one entity, but more often two or more persons will share in the ownership. Various forms of joint ownership are possible, including joint tenancies, tenancy by the entity, and tenancy in common. Married persons should be aware of whether the state they live in is a community property state. If it is, the spouse will take some interest in any property acquired during the marriage. Beyond traditional Land holdings. Modern real estate ownership may include interests in condominium, cooperatives, or time shares. The Statute of Frauds requires contracts for the sale of real property to be in writing. Such contracts must include the names of buyers and sellers, a description of the property, the price, and signatures. Most real estate is bought and sold through real estate brokers, who must be licensed by the state. Brokers have different kinds of agreements, including exclusive right to sell, exclusive agency, and open listing. Landlord and tenant law. Landlord-tenant law governs the rental of commercial and residential property. It is composed primarily of state, statute, and common law. The length of the tenancy is typically classified in one of four categories. Number one, term of year tenancy. The relationship lasts for a fixed period, which is agreed upon in advance by both the landlord and tenant. Number two, periodic tenancy. The relationship is automatically renewed unless the landlord gives advance notice of termination. Number three, tenancy at will. There is no fixed ending period. The relationship continues for as long as the tenant and landlord desire. Number four, tenancy at sufferance. The tenant continues to inhabit the property after the lease expires. Estate planning, wills, estates, and trusts. Wills and trusts are both estate planning tools that can help ensure your assets are protected and bequeathed to your heirs, besides your spouse, which is generally not an issue. Estate and gift tax law allows the passing of wealth to a surviving spouse without incurring gift or estate tax liabilities. However, the transfer process becomes much more involved when wealth is passed to a subsequent generation. It is possible to have both a will and a trust. All wills must go through a legal process called probate, where an authorized court administrator examines them. This process can be lengthy and potentially contentious if family members contest the will. Trusts are not required to go through probate when the grantor dies, and they cannot be contested. Insurance. Insurance is a contract represented by a policy in which an individual or entity receives financial protection or reimbursement against losses from an insurance company. The company pools clients' risks to make payments more affordable for the insured. Insurance policies are used to hedge against the risk of financial losses, both big and small. They may result from damage to the insured or her property, or from liability for damage or injury caused to a third party. There are many types of insurance policies. Life, health, homeowners, and auto are the most common forms of insurance. The core components that make up most insurance policies are the deductible, policy limit, and premium. Relationships between principal and agent. Any person who has the legal capacity, meaning that they are not insane or in certain circumstances a minor, to perform an act may be a principal and empower an agent to carry out that act. Persons, corporations, partnerships, not-for-profit organizations, and government agencies may all be principals and appoint agents. Any individual capable of comprehending the act to be undertaken is qualified to serve as an agent. A contract to be made by an agent on behalf of a principal is considered to be the contract of the principal and not that of the agent. It allows the principal to authorize somebody to carry out her duties either for a specific purpose, such as purchasing a house, or generally, such as to conduct many transactions. The agency relationship is usually entered into by informal agreement, but also can occur by formal agreement. That is, in certain cases, the agency relationship must be specified in writing. The acts must be legal, such as principal cannot hire agent to kill the professor. Termination of agency. Termination of agency takes place in the following circumstances. Number one, by revocation of authority by the principal. Number two, by renunciation of his authority by the agent. Number three, on the performance of the contract of agency. Number four, on the death of either principal or agent. Number five, by insanity of either principal or agent. Number six, with the expiration of time period fixed for the contract of agency. Number seven, by an agreement made between the principal and his agent. Number eight, with the insolvency of principal or agent in few cases. Number nine, when the principal and his agent is an incorporated company by its dissolution. And number 10, with the destruction of the subject matter. Hybrid business forms. This lesson provides a bridge between the partnership and the corporate forms. It explores several types of associations that are hybrid forms, that is, they share some aspects of partnership and some of corporations. Business people always seek to limit their risk and their taxation. A limited partnership is a creature of statute. It requires filing a certificate with the state because it confers on some of its members the marvel of limited liability. It is an investment device composed of one or more general partners and one or more limited partners. The limited liability company has become the entity of choice for many business people. It is created by state authority that, upon application, issues the certificate of organization. It is controlled either by managers or by members. It affords its members limited liability, and it is taxed-like partnership. Corporation general characteristics. Corporations have certain characteristics that are unique as follows. Number 1, capital acquisition. Easier for a corporation to acquire debt and equity. Number 2, dividends. A corporation pays its investors by issuing dividend to them. Number 3, double taxation. A corporation pays income tax on its earning. The investors must pay income tax on the dividend received. Lifespan. A corporation can theoretically operate forever, outlasting its owners. Limited liability. Any liabilities incurred by a corporation are not also transferred to its shareholders. Number 6, ownership. Ownership in a corporation is based on the number of shares owned. Number 7, professional management. In many cases, the investors who own a company are not actively engaged in its management. And number 8, separate entity. A corporation is considered to be an entirely separate operating and legal entity. Legal aspects of corporate finance. A corporation requires money for many reasons. There are 4 main sources of corporate finance. The first is flowback, or reinvesting profits in the corporation. The second is borrowing, commonly through a bond issue. A corporation sells a bond agreeing to periodic interest payments and repayments of the face value of the bond at maturity. The third source is equity, usually stock, whereby a corporation sells an ownership interest in a corporation. The fourth source is private equity and venture capital. Corporate finance is regulated through a variety of mechanisms through state statutes. A corporation must carefully weigh the pros and cons of each before making a decision to proceed on a particular financing path, as there are some legal aspects and procedures are connected and must be followed. Corporate powers and management. The corporations may exercise all powers expressly given it by statute and by its article of incorporation. A corporation generally has 3 parties sharing power and control: directors, officers, and shareholders. Directors are the managers of the corporations, and officers control the day-to-day decisions and work more closely with the employees. The shareholders are the owners of the corporation, but they have little decision-making authority. The corporation itself has powers, while a corporation is not the same as a person. For example, a corporation cannot be put in prison. It is allowed to conduct certain activities and has been granted certain rights. A corporation has 2 types of powers: express powers and implied powers. When a corporation is acting outside its permissible power, it is said to be acting ultra-vires. A corporation engages in ultra-vires acts whenever it engages in illegal activities, such as criminal acts. Securities Regulations. Many securities regulators around the world have demonstrated increasing interest in the relationship between sustainability issues and their core mandates. While their specific roles, responsibilities, and authorities differ from jurisdiction to jurisdiction, securities regulators are recognized to generally have 3 overarching and interrelated objectives. Number 1, to protect investors. Number 2, to ensure that markets are fair, efficient, and transparent. And number 3, to reduce systematic risk. This is because sustainability issues can create financially material risks and opportunities for investors and may affect the resilience of the financial system as a whole. Antitrust laws. Antitrust laws are regulations that encourage competition by limiting the market power of any particular firm. This often involves ensuring that mergers and acquisitions don't overly concentrate market power or form monopolies, as well as breaking up firms that have become monopolies. Antitrust laws also prevent multiple firms from colluding or forming a cartel to limit competition through practices such as price fixing. Due to the complexity of deciding what practices will limit competition, antitrust laws has become a distinct legal specialization. Unfair trade practices. Unfair trade practices refer to the use of various deceptive, fraudulent, or unethical methods to obtain business. Unfair business practices include misrepresentation, false advertising, or representation of a good or service, tied selling, false free price or gift offers, deceptive pricing, and non-compliance with manufacturing standards. Such acts are considered unlawful by statute through the consumer protection laws, which open up recourse for consumers by way of compensatory or punitive damages. An unfair trade practice is sometimes referred to as deceptive trade practices or unfair business practices. International law. International law, also known as public international law or law of nations, is the set of rules, norms, and standards generally recognized as binding between nations. It establishes normative guidelines and a common conceptual framework for states across a broad range of domains, including war, diplomacy, trade, and human rights. International law aims to promote the practice of stable, consistent, and organized international relations. The sources of international law include international customs, general state practice accepted as law, treaties, and general principles of law recognized by most national legal systems. International law may also be reflected in international comity, the practices and customs adopted by states to maintain good relations and mutual recognition, such as saluting the flag of a foreign ship or enforcing a foreign legal judgment. International law versus local law. International law differs from state-based legal system in that it is primarily, though not exclusively, applicable to countries rather than to individuals, and operates largely through consent. Since there is no universally accepted authority to enforce it upon sovereign states, consequently, states may choose to not abide by international law and even to break a treaty. However, such violations, particularly of customary and peremptory norms, which are called jus cogens, can be met with coercive action ranging from military interventions to diplomatic and economic pressure. The relationship and interaction between a national legal system, municipal law, and international law is complex and variable. National law may become international law when treaties permit national jurisdiction to supranational tribunals such as the European Court of Human Rights or the International Criminal Court. Sources of international law. Sources of international law have been influenced by a range of political and legal theories. During the 20th century, it was recognized by legal positivists that a sovereign state could limit its authority to act by consenting to an agreement according to the contract principle. This consensual view of international law was reflected in the 1920 Statute of the Permanent Court of International Justice and remains preserved in Article 7 of the International Court of Justice Statute. The sources of international law applied by the community of nations are listed under Article 38 of the International Court of Justice, which is considered authoritative in this regard. Number 1. International treaties and conventions. Number 2. International customs as derived from the general practice of states. Number 3. General legal principles recognized by civilized nations. Additionally, judicial decisions and the teaching of prominent international law scholars may be applied as subsidiary means for the determination of rules of law. You are watching YouTube channel ETV786. This channel is for everyone. Respected viewers, you can also watch basic concepts of accounting through above given 3 playlists and homemaking ideas and many more through multiple playlists public magazine, and subscribe the channel for upcoming shows. Bye bye till the next show.